that. Next few slides have the actual regulations from the State Department in the Foreign Affairs Manual. And within that, they do specify exactly what they consider to be permissible activities. And in general, these are what are considered permissible. So you can come here to meet with business colleagues, you can negotiate contracts, but you can't do anything that would actually be considered work. And among those, they have listed that you can do independent research. Some people do want to come in and do volunteer research at a lab, and that could be considered questionable if the whole concept of volunteering is really when you volunteer for a nonprofit, such as the actual volunteer work, like the working for the Red Cross. You're not, whenever you're doing something for which someone would actually get paid, even though you're not paid, that becomes borderline, gray areas where it's actually considered unpaid work and might run into trouble. So just keep that in mind in terms of what your plans are when you come to the U.S. On that B visa. You really aren't supposed to be working in a lab, even if it's considered unpaid, because then you're going to be helping somebody else who's a U.S. Employer doing their research, not your own independent research. I would say an independent research would really be something that you are doing on your own back home. You're coming to the U.S. perhaps to gather some information, do some research, and take that research back with you to your home country where you're actually going to write up the paper. So just keep that in mind when you are thinking about, what type of work you're going to be doing in the U.S., and that it's really not supposed to be considered any form of work someone would actually get paid for. Within the B1 regulations, there is a specific provision for medical students, and this is the clerkship, which most people do come to the U.S. to do. It is considered that would give you a slight advantage, perhaps, in your residency applications, having had some U.S. experience. For these clerkships, when you do go in saying that you're going to come to the U.S. for a clerkship, be sure to have the offer letters with you so that you can present those to the consular officer and also present those to the immigration officer when you arrive at the airport in the U.S. And these are limited to medical students only. If you've graduated, then the clerkship is really not considered, acceptable. There is another concept of an observership where you can come in, also do some, shadow a physician here. That would be okay as well. You just can't touch a patient. You're literally just that fly on the wall who's watching what's going on. And for observership, you definitely need to have a letter from the physician as well, inviting you for a few weeks to come in and do the observership, or if you're a medical student, to do the clerkship. All right. Medical doctors. This goes with the concept of the observership. You can't receive any remuneration for this. You can't actually engage in any form of patient care. You can't actually touch a patient. So it's really just to observe the medical practices. And again, if this is one of the things that you'll be doing when you're in the United States on that visa, definitely make sure that you have the letters inviting you to do the actual observership, and you can have a series of them, over a course of 1 or 2 months. But just have those letters with you when you go in for your interview. Remuneration. This is actually getting paid. You're not supposed to receive any form of remuneration when you're here on a business or tourist visa. And touched upon the earlier, but the unpaid research or internships, those really not considered acceptable activities to do on a B visa if that's something that somebody would actually get paid to do. Honorariums are acceptable, but those are for actual speaking engagements within a university setting, and they're very specific restrictions on the honorarium as well. If you're actually coming to the U.S., on behalf of a company to do work on behalf of a foreign company, there are certain incidentals that you can get reimbursed for by your employer abroad. But again, those are very limited to specific meals or lodging, some basic transportation as well. Okay. The period of stay is certainly something that they will consider when you're going into to the consulate and applying for your B visa, being very specific on what it is that you're planning to do and how long you plan to stay. And these are, they have to be realistic, and they really don't like it when people understand they can be here for up to 6 months and they just want to hang out, because that's not considered something that a tourist does. A tourist, if you think about it, is somebody who visits a country for a very short duration for actual tourism. And in these business visitor cases, there are specific activities that you can do, and documents that you present, should fall in line with how long you plan to be in the U.S. When you're applying for the B visa, just to keep in mind that you will obviously have to pay the MRV fee, and you have your passport, your DS-160. When you are preparing the DS-160, always keep a printout before you submit it, because once you've submitted it, you won't be able to go back and access the information that you provided on the DS-160. Always keep that copy of DS-160, on hand, because the consular officers and the immigration officers will have access and will know what you've stated in these, and certainly your answers can come back onto you on a future visa application. If you said one thing on a DS-160 and you're going back in the future for a different visa or another B visa, they will go back and look at your history of DS-160s, just see what was expressed before. You will definitely need to bring proof of your non-immigrant intent, and most of these refusals fall under this category of the 214B. Where basically they're saying that we're not quite convinced that that you're going to be going back home, and that we really believe that you want to stay in the United States to work or live there permanently. And so proof of your non-immigrant intent would be ties to your home country, that you have visa to come back to Pakistan, that you have work, you have property, you have family. So all of those documents you need to prepare and have ready to show to the officer as well. And then, you should have documentation about the activities that you're going to be engaging in. If it's for an observership, have the letters. If you're coming for your exams, then have the exam registrations. Interviews, have the invitations for the interviews as well. Definitely have all of those documented. They will also look at the time you spent previously in the United States. So this seems to be an issue that's coming up, that they're looking back on what had done in the past. If you had said you were going for an observership or a clerkship, do you have the letters confirming that you've completed that, or did you do you have your USMLE scores, to show that you actually did what you said you were going to do. So have the documentation related to what you've done in the past as well. Quite certainly, the State Department has also indicated that there's a new form that they're going to ask certain applicants to complete. It's called the DS-5535 form, where they're asking for additional information. And this form seems to be really, triggered for certain applicants. They're not doing this across the board, but if they think that there is security concerns, then they can ask for extensive travel history going back 15 years, phone numbers and emails. They could also ask for your social media platforms and your employment history. So those are, this is another additional form that's being introduced, where really trying to implement that extreme vetting, on these applications. During the interview, they're doing a few things. They're part of that security screening to make sure that that you're not coming into the United States to do some illegal activity, or that you're not a security threat. All these interviews are factual, determinations, and very often when a case is denied, it's based on what we gather to be true from the interview, and these are factual determinations. They're also going to be collecting your biometrics, which are your digital fingerprints and photo, and then the interview itself is with the consular officer. Very often it's very short, and you may feel that you don't have enough time to present all of your documentation or evidence that you've prepared. So consider having everything neatly organized and tabbed, and so that you can slip it under to the consular officer, and it would be very clear to them, and you would have that opportunity to present all the information that you've prepared. Once at the end of that interview, the officer will indicate whether or not it's been approved, or if there are concerns, and the visa itself is refused. They'll also indicate if there's going to be additional administrative processing, which is the security check, and or of course if it's denied. If there isn't any additional fees that are required based on your country of nationality, there are some additional reciprocity fees. At that point, you will be instructed to pay that additional fee as well. Just keep in mind that during the interview, try and keep your answers short and simple. Be honest and know your case, because the officer does have your visa history and travel history available, and you don't want to be caught in inconsistencies. Also have all of your documentation well organized and tabbed, and so you can present all of the documentation as soon as it's asked. And it is a very awkward public setting, but they seem to get annoyed if you're shuffling through your papers because you can't find everything. So just make sure that your paperwork is well documented and tabbed, so that it's easier for you to pull out, as you need it. The consular officer is going to be reviewing your DS-160 and will be, focusing on what it is that you're planning to do and what you have done in the past. And the level of scrutiny often depends on, which country you're applying in. Some posts are considered high fraud posts. You may find that other consulates in Europe, for example, or in Canada are considered friendlier posts because, they don't feel like everybody's trying to pull a fast one on them. Officers are also going to be reviewing for admissibility to make sure that you're not, somebody who's considered inadmissible. And often that would be on criminal grounds. If you have any form of arrest or criminal history, that's something that they would look into, and it may be a basis for a visa refusal under criminal grounds. So that's one. And then of course they want to just make sure that you're not somebody who's going to plan to immigrate or overstay or stay in the United States permanently when you're applying for that tourist visa. The administrative processing, I'm going to let Avi go into in more detail, but that's really the security checks. Okay, and with this, I'm actually going to hand it over to Avi to talk about third country national processing and visa denials. Avi?
Thanks, Naveen. When we talk about TCN processing or third country national processing, what that means is applying for a U.S. visa outside the country of your home residence. So if you are a citizen of Pakistan and you're applying at one of the U.S. consular posts in Pakistan, that's a home country application. But let's say you're already in the United States and you want to apply for a visa or to renew a visa, and you would like to consider applying at a U.S. consular post in Mexico or Canada that's outside of your home residence, that would be considered a third country national. When applying as a TCN, a U.S. consular officer is going to take into account various conditions in adjudicating the application and whether they will even consider the application to begin with. They will first look at, is this visa one of those residence abroad requirements? Is the presumption of, as Naveen mentioned, that 214B section of the Immigration Act, and generally that applies to B visas, J visas, and F visas. Are potential home residency requirements or fraud issues? Are you from a developing country or from a country that typically has high fraud in terms of documents? They will also look at, is hardship on you as the visa applicant to return back to your home country? Are you at a post that's adjacent to your home country? Does it make sense why you're there? Are you shopping? They consider shopping for the consular jurisdiction an issue. You know, they don't want to see you go to what's considered a friendly or easier post. There needs to be some nexus between why in the other country and the visa application. So, for instance, if you happen to be presenting at a conference in Paris, and during that time you also want to apply for your U.S. visa, then maybe it makes sense, and you can explain why you didn't have enough time to get back home and apply for the visa in your home post. And also take into account whether this is a first-time visa application or it's a renewal of a visa that's already been issued. The consular officers are a lot more comfortable after an officer has already made a decision on your case. So if you've been able to get your visitor visa or J visa or H visa, any U.S. visa in your home post, and it's time for renewal, and you're in the United States, they will oftentimes take into consideration and feel a lot more comfortable in accepting a case for review, and oftentimes that may lead to better chances of getting the visa issued in a renewal type basis. So we come to the next slide. Now, if you're in the United States, both Mexico and Canada have long-standing policies of accepting third country national non-immigrant visa applicants, and in fact, the TN program was established in those countries to take the burden off of assigning U.S. consular officers in overseas posts from a cost perspective and being able to man those consular posts. But you have to remember that the posts in both Mexico and Canada have different policies in terms of who they accept, and they frequently change their policy with little or no notice. So it's very important, if you're in the United States already and you're considering applying in Mexico or Canada, to consult with a knowledgeable immigration attorney about the current policies and procedures and would be an appropriate category for a visa application there. And a lot of people tend to forget, once they're in the United States, that Mexico and Canada are their own independent countries, and very likely you will need a valid visa for those countries to enter in, and that's apart from the whole U.S. visa application. And generally, if you're in the United States and you're applying for a Canadian visa, it can take anywhere from 2 to 8 weeks for the processing. In Mexico, it does tend to go a bit quicker when you apply for Mexican visa from the Mexican embassy or one of the many consulates throughout the United States. But here in California, where I'm based, I'm in Los Angeles. It's very easy to cross into Mexico. If you drive down to San Diego, it's easy to miss the sign that says you're now entering in Mexico, and a lot of times they don't even have be checking you as you walk into Mexico. So that's why it's very important before you plan on applying for your visa to check into the entry requirements for both Mexico and Canada. Go to the next slide now. Focusing for a minute on the U.S. consular posts in Canada, there's various consular posts that along the Canadian border with the United States and some on the interior. We have the U.S. consulate in Vancouver from the west, U.S. consulate in Calgary. We have the U.S. embassy in Ottawa, the U.S. consulate in Montreal, U.S. consulate in Toronto, and in Halifax, and there's a small, tiny consular post in Quebec City. Canada, in general, doesn't have a prohibition against third country nationals or limiting the types of applications. If you can schedule an appointment, they will allow you to apply. Now, just because you can apply does not mean that you're going to get the visa. And if you're in the United States and you're applying to renew a B visa or going for your first J1, you enter the United States with a B and applying for your first H1B, consuls in Canada can be very suspicious about why you are not applying back in your home country, and you'll need to have a very good reason about why you're in Canada. They tend not to like cases where you did enter initially or on your last entry enter status and are applying for a different category visa. Canada, if it goes well, the passport and the visa gets returned back within a few days. They have to undergo administrative processing. It can add weeks and sometimes months or longer to the visa process. Now we'll move to the next slide. And south of the border to Mexico, Mexico is a bit limited in terms of who they will accept. Years back, they would pretty much accept almost all cases, and in the last few years, they've become a bit more restrictive. Only for third country nationals, they're only looking at renewals of same category visas. They don't want to see any renewals for B1, B2s, or H2, which are temporary work visa categories. So, for instance, let's say you were able to get your J1 visa, you're in the United States, you've got a one-year J1, you're on your second or third year of residency, and you'd like to renew your visa with the same hospital. That would be a permissible visa to do in Mexico. But let's say you're on a J1, you're subject to the 2-year home residency requirement, you get a waiver, and now you change status to H1B and you're applying for your first H1B. Well, that would be permissible to do your first H1B in Mexico. Canada would probably accept that case, but Mexico would not. Also, some of the factors to consider is safety issues. There have been incidents in Mexico over the years of safety issues and concerns along the border, so you definitely want to check the Department of State's travel advisory section to see if there's any current issues in Mexico. Canada, I can't remember the last time there's been any issues around U.S. consular posts in Canada. Canada tends to be a very safe country for these applications, and logistics are very nice in terms of where these consular posts are located, and there's lots of hotels in the area, and they tend to be located in the nicer parts of town. Mexico, similar to Canada, the process takes at least a few days. In Canada, there is an extra step of applying or submitting your biometrics at a minimum 1 day before the visa interview. So you have to do your biometrics, and then the next day or a few days after, do the visa interview, and then you wait until the visa is issued and you get the passport returned via courier. So go to the next slide. In terms of visa validity and mission, these are two separate concepts. And the thing to understand is if you are approved for visa, this is a ticket to be able to board a plane to travel to the United States. It's no guarantee that you'll actually be able to be admitted to the United States. The admission process is controlled by U.S. Customs and Border Protection, or U.S. CBP. These are the officers that are stationed at all the U.S. ports of entry. So if you're getting at a U.S. airport, when you reach the U.S. airport, you will be interviewed by a U.S. CBP officer. They're the final decision maker in terms of whether they will let you into the United States. Now, the visa itself, the maximum duration is limited by what's called a reciprocity schedule. And the reciprocity is determined based on what the maximum visa duration is granted by the other country. So, for instance, if I, as a U.S. citizen, want to get a visitor visa for Pakistan, the Pakistani government will only allow U.S. citizens up to 5 years on that visa. Other countries, such as Europe or some of the Asian countries, will grant U.S. citizens up to 10 years. So based on what the other country does, the U.S. will do the same under what's called reciprocity. The maximum you can receive is a 5-year B1, B2 visa. What a lot of people don't understand is that does not mean that you're allowed to remain in the United States for 5 years. the visa itself is valid for travel to the United States for 5 years. So typically the validity is 5 years. It's a multiple entry visa that can allow you to travel back and forth for up to a 5-year period. When you get to the U.S. port of entry, it's now up to the U.S. CBP officer to determine, A, will they admit you? So they're looking again at those admissibility issues and confirming that the purpose of your visit align with your visa category. Generally, B visa applicants, if fitted to the United States, are granted a 6-month period of admission. Now, that's the maximum period that they're allowing you in for. Doesn't mean that you should stay for 6 months. It means that you could stay for up to 6 months. Now, while legally you could stay for up to 6 months, staying for long duration can have issues later on when you want to either apply for another visa or you're applying at port of entry. They will look at the duration that you stayed and the reasons why you stayed. When you're arriving at a U.S. airport, no longer does CBP issue the Y94 cards. If you're coming at a land port of entry via third country, such as Canada or Mexico, by land, you still issue the white I-94 cards. But once you've been admitted, what you want to do is go online and print your I-94 arrival departure record, and you want to confirm the date that you were admitted, the duration of your stay is correct, and visa category itself, because often CBP does make mistakes on these I-94 records. If you spot a mistake, you want to get that corrected definitely before you leave, and hopefully sooner rather than later when you do catch any error by CBP. And it can be corrected sometimes electronically online or via email, or have to go in person to a deferred inspection immigration office. We move to the next slide. So in the unfortunate circumstance where you are denied your U.S. visa application, what should you do? What is the procedure? Well, the first thing you want to do is look at why you were denied. And the consular officer is supposed to provide you with a visa denial letter. A lot of times these are pre-printed and they just mark or tick a box. And the most common reason for denial would be under 214B. This is when the officer feels you do not qualify for your visa category, and you have not been able to overcome the presumption of immigrant intent for your visa category. A 21G denial is a soft denial. That would have been if you forgot to bring a specific document or they needed more information or documents to complete your visa case. Helpful for us as immigration attorneys to try to understand what transpired at the visa interview, since oftentimes we're not able to be with you at the visa interview, is you to write down all the questions that were asked and the answers that you provided, what documents were reviewed and what documents were not reviewed. If you happen to know the officer's name or the window that you were at. And it's best to do this as soon as you can, not days after, but immediately following your interview while your memory is still sharp and you remember as much details as possible about the visa interview process. Step after reviewing it is if we feel that the officer has made an egregious mistake, it follow up in the chain of command within the U.S. consular post and ask consular section chief or the chief themselves of the the non-immigrant visa unit to reconsider the visa application. Sometimes they will do that, other times they will say no, and that requires a new application. In terms of, we often see this question, if you have a valid B visa and you're refused a J visa, what happens to your B visa? Or if you're from a country where you're eligible for the visa waiver under ESTA, can you still enter the United States? Well, I would say it's very risky because even if they've not canceled that visa, they have probably denied you under 214B grounds. And if you're able to board the plane when you arrive at the U.S. port of entry, the Customs and Border Protection officer will see you were recently denied, and they may deny your admission and cancel your visa and send you on the next plane back to your country. So it's very important to consult with an immigration attorney in terms of what happens in the case of a visa denial, and if you happen to have a valid visa, what your next steps may be. Sometimes we're asked in the case of a security check, is it possible to expedite? It's possible, but there's very limited grounds upon which you can submit an expedite. Your best bet to get that expedite done is when you're there in front of the consular officer, and to request the expedite based on a significant U.S. government or humanitarian concern. After you've left the U.S. consular post, trying to get an expedite done is possible, but it's very difficult to try to get an officer to recommend an expedite with the Department of State visa office. So we come to the next slide. Other we're seeing recently are non-immigrant visa revocations, and you can see the Foreign Affairs Manual site here on the screen. And revocations occur if a visa officer determines, A, that you're not eligible for the visa classification anymore, or if they feel that now you're subject to what's called a watch hit, promote hit, for an arrest or conviction of a driving under the influence. What happens with these visa revocations is the consular officer is supposed to notify the visa holder of their intention to revoke your visa. In theory, they should be allowing you an opportunity to show why visa should not be revoked. So you have an opportunity to revoke their intention to revoke visa. And if you're able to convince them otherwise, which is typically the case, they will ask you to submit your passport or other travel document in which the visa was issued so that they can physically put a cancellation stamp in there. So we can move to the next slide. Now, while officers can revoke a visa if you're eligible on a security ground, that's a 212A ground, no longer entitled to that visa classification, there's also a process known as prudential revocation, which really is a wide ground they could revoke on any reasons whatsoever. If received derogatory information from another governmental agency, most likely from an intelligence or enforcement community, maybe a name hit for a similar name that came in after your visa was issued. The key is that except for driving under the influence offenses, a consular officer cannot revoke a visa while somebody is physically present in the United States. They can notify you that your visa will be revoked, but once you're in the U.S., they can revoke once you've left. The exception exists for DUIs because DUIs are considered a very serious offense, and it's an indicator that you have a serious physical or mental disorder and that you've exhibited associated harmful behavior. And you don't even need a conviction for a DUI. All it takes is a simple arrest. Even if the charge is later stopped, they revoke your visa if there's a DUI incident. We go to the next slide. So what happens to your status if there is a visa revocation? Well, remember, the revocation does not terminate your status. If you're on a J1 or F1, that shouldn't terminate the SEVIS record. Also, your revocation as a principal, if you have a spouse or children, should affect them unless you're outside the U.S. and unable to get back. Normally, the revocation of a U.S. visa should not affect your status while you're physically in the United States. Generally, the revocation of the visa takes effect upon departure from the United States. Move to the next slide. So I have seen incidents where the visa revocation has had an impact on the status, and that's particularly with F1 students who are applying for optional practical training. Both the U.S. Immigration Service and Department of State have confirmed that revocation should not impact non-immigrant status, but there is a provision in the Immigration Act that does say that a visa has been revoked. It could impact your stay in the United States, and there is a risk that Immigrations and Customs Enforcement could put you into removal proceedings. So we go on to the next one. Now we're going to do a quick overview about security checks, the most common ones that we see. Mentis is the sensitive technology clearance based on whether what you would be doing in the United States falls onto one of the categories found on the critical fields list of Department of State's technology alert list. The issue with the Mantis is that this critical fields list and the technology alert list is no longer available or accessible to the public. You can search what used to be made available, but over the years it probably has changed. What the state is looking for is dual-use technologies or applications that may have benign technologies but have a dual use for a potential military application. And so if your research in the United States or your work in the United States or your presentation in the U.S. may fall into a sensitive technology area, you would likely be subject to a Mantis. The Mantis clearance can take anywhere from weeks to months until it's cleared. Again, the Department of State doesn't tell you that you're undergoing a security check. They use the phrase administrative processing. They won't tell you the type of clearance. That general phrase, administrative processing, and generally that's a code word for a security clearance. So let's move to the next one. The donkey hit, that's another security clearance based on your name. Generally, it's some with your same name is in a watch list, and there's not enough differentiating factors such as date of birth or say whether this person is male or female, or there's not enough biographical information, their height, weight, etc. So to have the same name as the person in the database, they have to clear you, and it goes through various U.S. government security agencies, and they have to concur with Department of State in the issuance. The issue with the donkey clearance is it takes many weeks to sometimes many months, and sometimes we had seen over the years many years to process. CIC is really if you have a criminal issue, and that's processed same day within the United States. So we can move to the next slide. If you are subject to administrative processing, and most likely it's a security check, well, how do you follow up? Well, the most obvious is to follow up with the U.S. consular post. Most of the time they have ways to inquire, and they set limits in terms of how soon after the visa interview you can submit your inquiry. You so to inquire with the Department of State National Visa Center, and you have the phone number here, 603-334-0888 to call in. It has to be the applicant or the representative making the inquiry, and they will just say, yes, your case is still pending, or your case is cleared, and now you can contact the post to the procedures to turn in your passport for visa issuance. APPNA also has a way by which you could inquire with them, let them know you're being subject to administrative processing, provide them with your passport biographic information, type of visa, and the date of your visa application and where you applied. And if it's undergoing too long of a process, they can try to follow up with the Department of State as well. Move to the next slide. Who are persons at risk for travel? And really it relates to immigration issues that you've had in the past. So immigration or status violations, meaning unauthorized employment, overstaying prior visas, a prior visa delay or denial, delays with USCIS when applying for a benefit or extension, problems at the port of entry. If you are routinely subjected to secondary inspection and prolonged questioning, there's likely a match for your name in the database. If you're born in or you've citizen of or you have patterns to certain countries that the United States has with or considers countries of concern, you may see issues with the visa process or the admission process. If you've ever had a criminal test, whether it's resulted in a conviction or not, we talked about technical alert, common name issues, terminations, even if innocent, can result in risk. So we can move on to our next slide. The role that we play as U.S. immigration attorneys in consular and visa processing. We get involved quite frequently helping people with their initial visa applications, even for routine matters such as a B1, B2, or J1. And what we do is help you, with the DS-60. We'll review your draft and give thoughts and feedback about your DS-160 to make sure it's accurate and correct. I'll put together a legal brief for the consular officer, so a packet, an attorney letter. We index all your documents that we feel are relevant. We got through the visa interview process, meaning preparing for the visa interview, talk about strategy, visa procedure, interview questions, do a bit of a rehearsal so you understand the questions, listen to your answers, and give you feedback. Some consular posts do allow attorney representation, most do not, and so oftentimes I travel with my clients to Canada or Mexico to call and be ready in case issues do arise. Keep track of the latest in terms of visa policies, procedures, and issues. In the unfortunate event that there's a visa denial, we will listen to the reasons for the visa denial and see if there's something that we can do to try to help out. Once that first denial, it's very difficult. Your chances diminish quite highly once you've encountered your visa denial, so your best bet is your first time to apply, and that's where the role of the attorney is going to make the bigger difference. On the visa denial, a shot and try to get something corrected after the visa denials, it's very difficult. In the fortunate event where you're subjected to a lengthy security check or administrative processing, we can also follow up with the consular post, try to put in the request for expedite, follow up with the Department of State visa office as well to request an expedite. So we can move next slide. Really, in terms of now, if you are successful in getting your B visa, you're here and you need to stay for a prolonged period, there is a way to file an extension of status. This is on USCIS Form I-539. It's filed with the appropriate USCIS Service Center and filing fee and support materials. Processing times for the B extension can go anywhere from a month or two to 6 months to 12 months or longer. The key is you should never overstay the period that you requested. So if you requested an extension for 2 months and EIS is taking 6 months, or you haven't heard back before your 2-month period, you want to ensure that you departed the United States before the period that you requested. Otherwise, it will be considered an overstay. Now, some people will depart the United States while the application is pending and before the Immigration Service has rendered a decision. Once you travel, that extension is going to be denied for your what's considered abandonment, meaning you traveled before there was a final decision. You must have really strong reasons for requesting additional time. Generally, it's going to be if you yourself have medical reasons why you cannot go back. You need to undergo a medical procedure. Let's say you're here and you need to take another exam, or you got late, last minute calls for interviews. You could probably extend for a bit of time, but it will be looked at relatively later on when you apply for either renewing your visa or applying for another visa category, or when coming in at the port of entry by CBP. Even though USCIS may have granted your approval, you have to remember that we have different agencies that handle immigration, and just because one agency approved it doesn't mean the other agencies will agree with the reasons why it was approved. So just because the Immigration Service granted your extension, when you apply for a visa, the consular officer that you face may not be happy and may not agree with USCIS, and likewise, Customs and Border Protection may take issue with extended stay in the United States and what USCIS has agreed to do. So we can move next slide. So to wrap up, you have both mine and Naveen's contact information. We're accessible oftentimes by email. If you have follow-up questions, you can look at your issues and see if a consultation would be in order. If you are looking to obtain Immigration Counsel, you can let us know what the issues are, and we'll see how we might be able to help you and give you some feedback about what our assistance might be. We have a toll-free number, which is 800-VISA-LAW. The main line is 310-570-088. And both myself and Naveen are available, to take questions by email and to see how we might be able to assist you with the visa process or with other non-immigrant or immigrant visa questions. Now I wanted to open it up for questions. Naveen, do you want to see if we have some questions? All right, I see some questions pop up. I don't know if, Naveen, you can hear me, if you're working. One question we received was saying the person was denied on January 17th and then April 3rd under 214B, under the 214B category. Should I reapply? Again, I think this is one where you should consult with an immigration attorney about the reasons for denial, how strong your ties are back to your home country, what are the reasons why you were denied, what were the concerns that the visa officer had. I mentioned in the presentation, if you have one denial, it's almost like a slippery slope. It's downhill from there. Even though you'll be interviewed by another consular officer, it's very difficult for that second officer to overturn their colleague. So they tend to do a very cursory interview and look at notes that the first interviewer put in the system, and they may be very abrupt with you and say, why are you here? What has changed from your last interview? And they'll probably, if you're not prepared and not ready, will through with the denial again. Here's a follow-up to that saying, the second time the officer told me, father's not sponsoring me, why am I sponsoring myself? Well, if I let my father sponsor me the next time? Again, we need to really examine what were the issues that they had, what are the reasons why you're coming to the United States, and can you meet those requirements?
Can you hear me now? I think I've unmuted myself, but so there was this question about a third time that you've been practicing for the last 2 years. If you passed up 2CS, then you're going to be practicing in the U.S. for 3 years. I'm not quite sure that means that you've already been in the U.S. for 2 years, or the practices have been in Pakistan, but I think, you really need to emphasize how long you're planning to stay in the United States and what it is that you're planning to do. We typically say that if you've had 2 or 3 denials, then it's probably best to apply for an H. And I understand that that's a very high order to meet, but if that would really be the only way to overcome. And I don't know if you would really be to have a third time being the charm and getting it approved on your third application. Avi, did you want to add anything on that for a third time?
Yeah, I tend to agree that, again, it's this slippery slope, and every time you apply and you get a denial, the chances of an approval is going to be diminished. So you really have to be able to come up with strong documents and evidence about what is different this time and why you qualify and how you plan on overcoming the presumption of immigrant intent, the BJ or F visa. The H-1B is a dual intent visa, so as Naveen mentioned, I bet if it's a 214B denial is to apply for a visa that does not have that requirement, and that's going to be the H-1B, which is a dual intent visa. Proving immigrant intent is a factual determination, and it's made by the consular officer. It's elicited through the interview itself, the questions and answers. The documents are secondary. It's being able to prove what are your ties back to your home country that will compel you to return. Why will they believe that you have no intention of staying long-term in the United States? Knowing that you and your family have bank accounts, that you have property, that you have businesses, that all family members are in your home country. Being able to document all these various things are ways to try to convince the consular officer. So again, it's this factual determination, and it's officers oftentimes go based off of their instinct. And if you have all the right materials to present to them, you still could end up with a 214B denial. It is a discretionary decision. It's fact-based, and there really is no way to challenge them outside of the interview process.
I did want to just make mention of one thing. Since we are seeing such high number of refusals for the Bs and Js this year, a member of our Bar Association has also raised this issue with the Department's visa office, and we're hoping that there's going to be some clarification as to exactly what's going on here, because it is true that it seems like they're changing the rules of the game this time around, which is quite fortunate. Avi, there was another question about a 3-time denial. The first time being that the interviews were scheduled. Second time, there were 16 interview letters and step 3 exam letter. And then the third time, in to show the 214B docs along with a prospective employment letter, and again, this is refused, saying that she didn't have enough experience, which doesn't make sense since it's internal medicine residency.
Yeah, a lot of the decisions of the consular officers don't make sense, and your best bet there would be a request for reconsideration. Try to get the case looked at by a supervisor within the visa department. There's no certainty that somebody will look at it, but if it's an egregious denial and there's strong supporting documents to back all the all the reasons for traveling to the United States, then you have a better chance that they may re-look at it and you may have a shot. But again, there's no assurances or guarantees about what's going to happen. Will require that you pay the visa fee again and have another interview.
Okay. At this point, I think we've reached the end of our hour, so we'll end the webinar now. For those people with follow-up questions, or if you want to have a specific consultation on your specific issue, both Avi and I are available. So please do email us, and we can set up a time to go over your specific situation. My email address is nbhora@wolfsdorf.com, and Avi's is a.friedman@wolfsdorf.com. I will just type it into the web chat so everyone can see it as well. Okay. I think with that, Avi and Nicholas will end the webinar. Thank you.
All right. Thank you, Naveen and Avi, for giving us the time. And I mentioned if you have any questions, feel free to email Naveen. And any concerns you have, you can also email to us directly as well. Thanks, everybody.